The appeal chamber further notes that Milošević was convicted for both planning and ordering the campaign of shelling and sniping of civilians in Sarajevo during the indictment period, subsequent to Galić's term in command. With respect to the actus reus of planning, the trial chamber held that although Milošević did not devise a strategy for Sarajevo on his own and acted in furtherance of orders by the VRS main staff, he was able to implement the greater strategy in a manner he saw fit. It is unclear from these findings whether Milošević was found to have participated in the design of the military strategy concerning the ongoing campaign as such, or whether he planned each and every incident for which he was held responsible by the trial chamber. The appeals chamber further finds that it is unclear what specific evidence was relied upon by the trial chamber to come to these conclusions. In light of these uncertainties, the appeal chamber finds that Milošević's responsibility for planning the campaign of sniping and shelling of civilians in Sarajevo as such could not be established beyond reasonable doubt. The appeal chamber emphasizes that the findings above pertain strictly to Milošević's individual criminal responsibility. These findings do not affect the conclusion of the trial chamber, as well as those of the Galić trial and appeal chamber, that a campaign of shelling and sniping the civilian population in Sarajevo took place during the relevant period. The appeal chamber now turns to consider Milošević's responsibility under counts 1, 5, and 6 concerning the shelling incidents. On the basis of the evidence relied upon by the trial chamber, coupled with the established fact that Milošević was directly involved in the use and deployment of modified air bombs and issued orders regarding their use from as early as August 1994, the appeals chamber is of the opinion that it was not unreasonable for the trial chamber to conclude beyond a reasonable doubt that all the shelling involving modified air bombs and mortars fired by the SRK in Sarajevo during the indictment period could only occur pursuant to Milošević's orders. However, the appeal chamber notes that the trial chamber's conclusions that Milošević planned the shelling incidents are based on essentially the same set of facts. In the circumstances of this case, the appeal chamber proprio motu finds that Milošević's responsibility for ordering the shelling incidents fully encompasses his criminal conduct and thus does not warrant a conviction for planning the same crimes. Considering Milošević's responsibility under counts 1, 2, and 3, which concern the sniping incidents, the appeal chamber finds that the trial chamber abused its discretion by taking into account instances where Milošević acted towards preventing the sniping as proof of him planning and ordering the sniping of civilians. Second, the trial chamber's reference to an order for combat readiness and to draw up a firing plan onto the old town as an example of Milošević planning and ordering the sniping is not accompanied by any mention of an exhibit of witness testimony, and the appeal chamber is unable to discern what exactly the trial chamber was citing to. Furthermore, the appeal chamber finds that the evidence cited by the trial chamber in supporting of its finding that Milošević generally controlled the sniping activity and training does not allow for a conclusion that the inference by the trial judgment that Milošević ordered all sniping incidents attributed to the SRK snipers is the only reasonable one. However, the appeal chamber notes that its findings above do not exclude Milošević being held responsible for the crimes committed through sniping under Article 7.3 of the statute. considering that this mode of liability was pleaded in the indictment and discussed in the trial judgment. The appeal chamber is satisfied that although it did not convict Milošević under Article 7.3 of the statute, the trial chamber made the findings necessary for the establishment of his command responsibility for the sniping incidents. Having applied the correct legal framework to the conclusions of the trial chamber, the appeal chamber is satisfied that Milošević's responsibility under Article 7.3 of the statute for having failed to prevent and punish the said crimes committed by his subordinates is established beyond reasonable doubt. The appeal chamber now turns to consider Milošević's arguments raised under his fourth ground of appeal, claiming that he cannot be held responsible for planning and ordering the incidents that took place between 6 August and 10 September 1995, while he was receiving medical treatment in Belgrade, namely the shelling of the Bitas building on 22nd August 1995 and of the Markale market on 28 August 1995. The appeal chamber recalls that while Milošević was hospitalized in Belgrade, the person in charge of the SRK command in Sarajevo was his chief of staff, Dragomir Milošević, who issued orders in lieu of the commander. Therefore, the appeal chamber finds that even though Milošević formally preserved his rank and duties, the position of authority on the ground belonged to the stand-in commander, albeit temporarily. The prosecution suggests that it can be inferred from the totality of the evidence that prior to his departure, Milošević instructed Sladoje to continue the campaign in his absence. However, the appeal chamber observes that this argument was not part of the prosecution's case at trial and was thus not considered by the trial chamber. In any case, the appeal chamber is not convinced that such an inference would be the only reasonable one from the evidence pointed to by the prosecution. The appeal chamber notes that the trial chamber did not establish the existence of the prior positive act required for the actus reus of ordering with respect to the 2 shelling incidents at stake.